Hello, everyone, and welcome to the United States Patent and Trademark Office webinar on trademark scams. My name is Marisa Terrell, and I'm an attorney in the Trademarks Customer Outreach Office. I'm pleased to serve as your host today. As you may know, our agency and our customers have experienced an increasing number of scams intended to defraud trademark owners. Well, today we will discuss practical tips for protecting your brand, your clients, and yourselves from these fraudulent activities. Now, before I introduce our subject matter experts, I'd like to share just a few announcements with you. First, this session is being recorded for your convenience and captioning is available. You'll have access to the recording in about 3 weeks or so by visiting our website, uspto.gov. Today's presentation features a number of terrific slides. These slides will be emailed to you after the presentation. And at the conclusion of the presentation, provided we have enough time, we'll open up the discussion for a Q&A portion. So you'll be able to submit your questions via the chat box. Simply type in your question and hit enter. Finally, please be aware that the chat thread should be used for questions only. Okay, so thanks for allowing me to run through all those announcements. At this point, I'd like to introduce our three expert presenters. Our first expert is Sarah France. Sarah has been with the U.S. Patent and Trademark Office since 2015 and is currently a staff attorney in the Trademark, Electronic Filing, and Public Web Services branch. We also have attorney David Mayer. David is a staff attorney in Trademark Legal Policy Office, where he has been a specialist on improper filing behavior for the past 5 years. He's also a former examining attorney. And finally, we have Dustin Bednarz. He's an attorney with the Trademark Legal Policy Office. Attorney Bednarz has been with the U.S. Patent and Trademark Office since 2015, and he joined the agency as a trademark examining attorney. Sarah, David, and Dustin, thanks so much for sharing your expertise with us.
Thanks so much, Marisa. All right, I'll go ahead and get us started. All right, today we'll be discussing several topics. First, I'll give you a brief introduction. Then we'll be discussing a few rules about representation before the USPTO. And then finally, we'll discuss several of the scams that we've seen, including trademark filing firm scams, false solicitation scams, phone spoofing scams, post-registration solicitation scams, and finally, ID verification scams. And then at the end, we'll share some tips for attorneys, applicants, and registrants to protect yourself from scams. So why a webinar on scams? Many government agencies, including the USPTO, have seen a steady increase in the number and variety of scams targeting our customers. Here at the USPTO, the scams we are seeing relate to all phases of trademark registration. Some target individuals who have not yet filed a trademark application, but perhaps are working on designing a logo for a business. Some target individuals who have filed a trademark application with USPTO, and others target those who already have a registered trademark. And there are new scams every day, many of which are more sophisticated than the last. The goal here today is to give you some tools to help you protect yourself, and if you are an attorney or clients, against some of the scams we are seeing targeting USPTO customers. The USPTO has several measures already in place in an effort to protect the trademark register from scammers. These include administrative sanctions, such as termination of applications or sanctioning of registrations through show cause orders, third-party petitions and director-initiated expungement and reexamination proceedings, as well as letters of protest, post-registration audit and maintenance filing deletion fees, and finally, scam awareness measures, such as the webinar you're watching today, to help filers and their attorneys protect themselves against scams. Because the USPTO has seen scams grow in number and sophistication, we are providing our customers, such as yourselves, with tools to recognize scams and hopefully prevent them. We have revamped our web pages on scams and are continuing to do so. We have refreshed our application filing receipts and registration notice emails to raise awareness of scams. And we are providing social media posts and webinars like this to hopefully keep our customers apprised of the latest scams. For a sampling of scam prevention resources offered by the USPTO, once again, please see the handout you received called Trademark Scams, How to Avoid Them, and What to Do If You Get Fooled. So with that, let's jump right in. Because many of the scams we see involve a scammer reaching out and offering to represent an applicant or registrant before the USPTO in a trademark matter, we wanted to start by giving you a brief reminder about who can and cannot represent you in trademark matters before the USPTO, which can also be found in 37 CFR 1114. So, if you are a US-based applicant, you can be represented by a US licensed attorney, which we recommend both to help you through the process and to serve as a buffer to scams. You can also act on your own behalf in a trademark application or on behalf of a business you own. If you are not a US-based applicant, you must be represented by a US licensed attorney under 37 CFR 2.11. Why all of this? Because remember, applying for a trademark is a legal proceeding, and failing to adhere to the rules can result in a defect in your application that may result in your application being refused or may call into question the validity of your registration. Unfortunately, we see this often, and often after an applicant has paid a large sum of money, sometimes to a scammer. So with that, I will turn it over to David, who will discuss some of the trademark filing firm scams we have seen.
Thanks, Sarah. So the first question that you may have is, what do we mean by a filing firm? Well, these are businesses mostly operating online that advertise low-cost trademark application and registration-related filing services. They're advertising that they can help you file new applications, submit responses to office actions, or help file other documents with the PTO. And as Sarah just discussed, only an attorney can represent others before the USPTO in trademark matters. So there are legitimate law firms that operate websites that offer trademark services that are not scams, but what we're concerned about here are websites that offer these services without attorneys or proper attorney supervision. Sometimes bad actors may try to make you believe that you're working with an attorney, so we want to teach you to look out for these false claims. The handout for the presentation has a link to our filing firm website that includes tips that can help you make sure that you're working with a legitimate attorney. But generally, beware of companies that say they aren't law firms, but that they are allowed to do trademark work. Be cautious of people on personal service websites like Fiverr.com that claim to be able to practice before the USPTO, even though they're not clearly attorneys. And during this presentation, we're going to discuss and actually show some examples of specific scams that we're seeing. But I want to make sure you're aware of what we're hoping to show you. We want you to be aware about conflicting mark notices, impersonation of attorneys, fake USPTO correspondence, fake cease and desist letters that claim to be from actual law firms, and alert you to potentially unethical attorney cooperation solicitations. One theme that I want to make you aware of early on in this presentation is false urgency. We're going to hit that term a lot, but essentially a scam will often try to make you take action very quickly, not leaving you time to investigate whether the correspondence is legitimate or not. I also want to start out by letting you know that you can always contact the Trademark Assistance Center or forward suspicious email correspondence to us to help you determine if it is suspicious. I want to start out also by talking about a recent example of one of these filing firm scams, and that is Abtac and several of its subsidiaries. Now, this entity was sanctioned in 2022. It was operating dozens of alleged low-cost registration websites, but also logo design websites, and we're going to talk a bit about that more in a moment. These entities were advertising flat rate pricing on search engines, and in the example that you can see on the screen here, they would sometimes even say that they are recommended by the USPTO. Now, the USPTO does not recommend that you use any filing firm. We don't even recommend attorneys. We can point you to resources, but the USPTO never makes recommendations. Now, this entity was known to be overcharging filing fees, often improperly notifying customers that they had to pay for multiple classes. And we're going to talk a little bit more about that. They would file for goods and services that were different from what the customer may have been led to believe would be filed. They would enter false signatures and sometimes even doctored filing receipts and office actions to make it seem like more fees were due. Thousands of trademark applications related to this particular scheme were terminated as part of the scam because the USPTO couldn't even rely on any of the information in the applications as being true. Despite the sanctions, Abtac and potentially several other entities following its lead are likely continuing to engage in similar conduct. There are hundreds of additional logo design and alleged low-cost registration websites that continue to operate. The scams keep getting more complex too. We're going to show you how these flat rate fees and tend to escalate very quickly. With that, we're going to turn to false solicitation scams. Now, this is not entirely separate from filing firm scams. False solicitation is the method through which many bad actors try to reach out to potential applicants or sometimes even attorneys. Some victims may be taken in by advertisements made by unauthorized filing firms, but we're also aware of several ways that bad actors use false solicitations to contact these potential victims. Beware of unsolicited communications via email, text, or phone call that relate to either a logo you may have paid to have designed online or an existing trademark application or registration. Again, false urgency is something we want to flag for you, particularly where immediate payment is apparently required. So we do note that the trademark application process is a legal proceeding and there are deadlines, but we do not have official deadlines that are only a few days long. When you see a deadline of 24, 48, or 72 hours, this is something bad actors often employ to get you to rush and avoid investigating whether that communication is legitimate. We want you to be aware that bad actors can spoof the identity of the sender. We've even seen fake USPTO letters and office actions. We've seen fake cease and desist letters that name real attorneys at real law firms, but which contain fake correspondence information. Now, I want to let you know an assigned examining attorney could call to offer an examiner's amendment, but pendency is currently about 8 months long before the applications are even assigned to an examining attorney, and even then, that examining attorney would never ask somebody for payment information over the phone. Other than this situation where an examining attorney calls to offer an amendment, it's incredibly rare to receive a phone call from the USPTO about your application. So I want to jump in to show you some actual examples of things that we're seeing. Logo design companies and unauthorized filing firms sometimes employ fake USPTO search reports. It's common for a law firm to offer a search report and opinion ahead of filing a trademark application to help determine if the use and registration of a proposed mark is legally safe. But that's not a service that the USPTO offers. We do not do clearance searches or offer opinion letters. As mentioned before, bad actors will sometimes charge excess fees per class and suggest that the USPTO has determined those necessary fees during some sort of pre-search process. Again, this is not something we do. We don't send out reports of any sort with the logo plastered at the top of it like that. If someone forwards you correspondence allegedly coming from the USPTO, be on the lookout for certain suspicious markers. One of those is clear typographical errors or grammatical errors. In this particular case, there are words missing from this sentence such that it doesn't actually make sense. It says, and how to respond to them or working on them. At the end. Now, examining attorneys are human. The USPTO, I'm not going to claim that I've never sent out some sort of communication that had a typo in it, but we're looking at red flags that, especially when you see grammatical or typographical errors across an entire document. We want you to be on the lookout for nonsensical citations to law. Now, the lawyers who are present probably would recognize that Act 1972, Section 80-247(1)C(f)(51) is not how a legal citation should work. We understand that if you're not an attorney, you may not understand necessarily or recognize a proper citation format. If you see a citation to law that looks a little bit wonky, do an internet search. If you were to search this particular phrase, you probably wouldn't actually turn up anything that makes any sense. This one's a little tougher to spot, but beware of incorrect contact information in the correspondence. In this particular case, the telephone number there is not actually a USPTO telephone number. Most of the time, if you search a telephone number of an office at the PTO, you'll actually turn up our website. Here also, the address that is listed is for the Information Products Division. That is not a trademark-related office. It's actually an office that I believe handles certain publications for the Patents Office. Not something that would make sense in a trademark-related letter. Also be on the lookout for strange disclaimers. Now, the USPTO is an agency that is performing a public service. We don't have need to disclaim what it is that we are doing here. And in this case, it says that the USPTO disclaims all warranties and representations express, implied, or statutory with regard to its products and services. Well, we don't have products, and the service we are providing is the public service of registering trademarks. If you see a disclaimer like this, it's definitely a red flag. Finally, on this one, I just want to point out that it indicates in the middle that priority action is required by the applicant. That's that false urgency we keep talking about. Now, if you receive correspondence forwarded to you that is allegedly from the USPTO, you can always check the Documents tab in TSDR, the Trademark Status and Document Retrieval System. It's tsdr.uspto.gov. You can enter a serial number or registration number and look at the documents that are actually connected to your application. If the document is not there, be skeptical. Particularly if it's substantive like this, something that looks like it matters to the process. We always save documents to TSDR. Now, this is a common scheme that we've been seeing, this idea of fake solicitation about a conflicting mark. We want you to be aware of this because bad actors will claim to be a law firm, a filing agency of some sort of other filing entity, sometimes even the logo design company itself. And they're going to tell you somebody sent them a trademark application for your business name or logo and that they'll help you get that mark instead of that other party. If you had a logo designed online, the design firm and some of these filing firms are known to be operated by common parties. So we want you to be aware of these false claims. First, a real law firm would not make this type of claim. They're not going to claim that they received an application, but they want to work with you instead. Law firms don't do that. They won't drop one client in favor of picking up another one. This message also says that the USPTO and IP protocols suggest giving priority to the business name over the new applicant, but that's not actually how examination at the PTO works. One, there is no special IP protocol, and absent a petition to make special, which is an incredibly rare thing, the USPTO generally considers applications in the order that they are filed. If you have a dispute over priority of a mark, who is using the mark in commerce first, that requires parties to actually go to the Trademark Trial and Appeal Board or a court of competent jurisdiction to work out. Bad actors also will claim that if you take no action, somebody else is going to own that trademark, that logo or your business name. But trademark rights are based on use of a mark in commerce. Now, registration of a mark with the PTO gives you certain benefits, but it's never actually required. We're also worried here about again, my common theme, false urgency. Here, it says that the victim only had 2 business days to register. Otherwise, the other party, who I note was unnamed in this, would get the mark. That's another little bit of a red flag. You want to be aware that if somebody is claiming that 2 different parties might own the mark and that there's some sort of priority dispute, well, a letter like that would actually name the other party so that you could investigate or look into who has superior rights to the mark. So we also see bad actors actually impersonating the USPTO on correspondence. Bad actors might sometimes forward official-looking correspondence that they claim came to them from the PTO. If you have an attorney, the USPTO corresponds with your attorney. The USPTO doesn't send notices to filing firms or logo design companies making demands about applications, often that haven't, as they claim, often ones that haven't even been filed yet. So we want you to be on the lookout for signs that the correspondence is not genuine. One is typographical errors again. Now again, examining attorneys are human and can make mistakes, but in this case, the typographical error is right in the letterhead. The United States Department of Commerce is the department over the USPTO. It's not spelled department. Also to note in this particular one is that it identifies the wrong office. It says the Patents Office, let alone the problem with the apostrophe there. The Patent Office is not the Trademark Office. Now, the USPTO handles patents and trademarks, but there is a patent office within the USPTO and there is a trademark office. The patent office has nothing to do with registering trademarks. So if you see something referring specifically to the patent office or patents office, be wary. Also look out for nonsense fees. There is no such thing as a registration ID issuance fee, and there are certainly no federal taxes owed on federal trademark submissions. Along with your handout, in the handout, there is a link to our actual fee schedule. I'm going to talk a little bit more about the fee schedule in a moment, but be aware that if you see a fee and you don't understand what it's for, you should search it. Search what that fee is, what it means, when it would be due, because bad actors will sometimes, they're always trying to extract another fee from you. Finally, I want to point out the government seal here. Now, bad actors frequently like to misuse government seals. The USPTO doesn't issue official office actions with the seal plastered all over it. Notice in this case, it's in the letterhead, it's in the watermark on the background, and then they put this raised, what appears to be a raised seal in the bottom corner. The raised seal is intended for use on presentation copies of certificates, and a version of it does appear on the electronic registration notice, but we don't plaster the seal over just general correspondence that we send out. When in doubt about correspondence like this, contact the USPTO using direct email or contact phone numbers published on our website. You can also contact the Trademark Assistance Center to help you authenticate something. You could also, again, see if the USPTO actually sent the document by checking TSDR in the Documents tab. And we're going to discuss later, but the USPTO is also not the only agency that deals with impersonation issues like this. So official documents are not the only problem. We also see emails impersonating the USPTO. This is a very recent example. The victim realized that the bad actor was a scammer and then disputed a large credit card charge. In return, the bad actor sent this message that it was allegedly from the USPTO telling the applicant that if the fee wasn't repaid, the applicant wouldn't be able to reapply for the mark again for 5 years. So what can you look for here? Well, one thing is that emails from government agencies originate from .gov addresses, not .org addresses. Bad actors will sometimes mask this further by creating domains like uspto.gov.us. So be very careful about paying attention to the end of the email address. Also notice that here it says uspto.gov first, outside the brackets. Now, that's something that's changeable in your email program. If you've noticed, sometimes when you send a message, it'll have somebody's first name and last name. Well, somebody in this case just set the name to be uspto.gov. So that's something to be aware of. The USPTO doesn't communicate with trademark agencies in this manner, and we wouldn't direct anybody to pay a third party. Even if there were a financial dispute between a client and an attorney, that doesn't affect the underlying application. We don't get involved in that relationship. So we would never tell you, you need to go pay this third party. Again, be aware, look for typographical errors and references to non-existent rules. Here again, it says you will not reapply for the same mark for next 5 years. Again, typographical or grammatical errors. And there is no such rule. You can reapply for a trademark at any time, even right after getting a refusal. There's no rule that requires parties to wait for 5 years. And of course, notice the false urgency. If you don't take action within 24 hours, something's going to happen. Be very skeptical when you see those quick turnaround deadlines. Bad actors have been known to try to prove that they are doing work for you by showing fake certificates. Now, one thing I want to note is that trademark certificates don't actually look like this. A real certificate identifies the mark, the owner or registrant of the mark, the goods and services with which the registrant uses the mark, and certain other information. So in this case, the certificate has a seal that isn't the USPTO seal. It doesn't have any reference anywhere on here to any goods and services or even who the registrant is. Be on the lookout for tampering. Now, it's difficult to see on your screen probably, but if you look very carefully, you might even see that there's a slight gray box around the words "your trademark" here. That's a sign of tampering. It looks like the image has been digitally manipulated to make it look like your particular trademark appears on it. Scammers are sometimes very good at doing this and blending it in, but look at these images very, very carefully. There's also, in this case, an interesting problem with the signature itself. Now, this would be a difficult one to catch for most people, but in this case, the signatory is listed as the acting commissioner for patents and trademarks. We want to let you know first that there is no commissioner for patents and trademarks anymore. There is a commissioner for patents and there is a commissioner for trademarks. Regardless, we no longer have people sign in an acting capacity. All of our trademark and for that matter, patent registration certificates are signed by the director or a person performing the functions and duties of the director. In this case, too, the actual alleged signatory is a person who helped run the agency in the late 1990s and early 2000s, but has since actually passed away. So this signature is bad for that reason too. I want to show you a real trademark certificate. This is a recent example. The gold seal is new on these. But you'll notice that the mark appears on top. There is what's blurred out, but you can see that there is a spot for the registration number, the date that it was registered, the classes of goods and services. At the bottom, there is a serial number that from which the registration originated, the date it was filed. There's a lot of information here that would tell somebody looking at this certificate, what is the mark, who owns it, and what is it used for, and when was the person using it in commerce. None of that is present on that phony certificate. We've also seen invoices. Now, big takeaway, the USPTO does not issue invoices at all. We don't send out bills with the logo sitting up on top like this. And fees that accompany real submissions to the USPTO are paid via either credit or debit card at pay.gov, or as some of the attorneys attending this webinar might know, deposit accounts. They're always handled, though, while the submission is being made through the Trademark Electronic Application System, or TEAS. So if you receive an invoice purporting to be from the USPTO, huge red flag. We don't do this. Look out for these nonsense fees. Now, the handout contains a link to our current fee schedule, but as I sort of hinted at before, be aware that scammers might try to charge you fees that look real, but aren't actually part of the application process. Sometimes they'll use the fee schedule as almost a menu and just indicate that all the fees are owed at the same time. And that's not true. We want you to be aware that you need to be cautious about paying for fees for more than one thing at a time. Most fees at the USPTO are single fees for a single transaction. We commonly hear about scams that involve attestation fees or 50-state attestations, but that is not actually a USPTO trademark-related fee. There's no such thing as an attestation as part of the normal trademark application process. Also here, it says EIN business number registration. The USPTO doesn't register employee identification numbers, and we actually don't handle these types of numbers at all. We treat this as sensitive information, similar to a social security number. The USPTO doesn't want this information, and we would never ask you for this information. It's not pictured here, but remember that a lot of scammers also try to charge victims multiple class fees. And so they'll sometimes do this by referencing the US class designation in an application. The USPTO, like most offices around the world, use international classes to group together like goods and services. Now, our systems will sometimes still reference the US class designation, but all of our fees are based on international classes. If you get a response from a filing firm telling you that you owe multiple classes worth of fees, you can visit our website and look at the manual, the identification manual, and enter a few of the goods and services, and you'll see what international class they are all related to. If they're all in the same class, that would be a single filing fee. So just be aware of that. These types of unexpected fees are how the bad actors turn that flat $49 or $99 registration into a much more expensive scam. I also want to flag for you that bad actors are always trying to extract just one more fee. Once you pay this, you are done. Now here it says final payment, nothing else required for you to pay in future. First, there's no such thing as a lifetime trademark registration. There are periodic fees that are due, and Dustin will be talking a little bit about that in a bit. But this is a tactic they are using to try to get one more thing. Oh, you paid all that, but that was last month. It turns out that there's this one more thing that you owe. Once you pay this one, you're done. They'll keep doing that. So be on the lookout. So perhaps one of the more difficult scams to spot is where somebody contacts an applicant claiming to be an attorney who can help. When you file a trademark application, certain information is made part of the public record. If an office action issues, that's also part of that public record, and some services monitor the serial numbers of applications that receive office actions. Legitimate attorneys sometimes use that information to solicit business. They'll email you and say, it turns out you received an office action. Would you like an attorney? I can help you. But bad actors can use that information also. Now, this is a very real example, and we blurred out certain information. Bad actors will try to convince you to use their services sometimes by claiming that they have some sort of special process through which they can shorten the registration process to just a few months. Well, there is no such thing as this special process. As I said before, the pendency currently is about 8 months before an examining attorney reviews the file. And the entire process, even if things go smoothly, it does take several months past that point. You're looking at usually a year to do this. And if you're being contacted at the point that you've already received the office action, there's no way to short circuit the process like this. This alleged attorney also advertises that no automated bot or AI will be used in the process. That should be a red flag, because generally you should be assuming that a real attorney is not giving his or their legal work to a computer to do. You're hiring a lawyer for their legal expertise, not because they have access to some sort of AI. Beware that bad actors can claim to be attorneys. Here, the photograph was actually two different lawyers from two different law firms sort of stitched together. We were able to find the original photographs. And they can create websites. Anybody can purchase a domain name that has the word law in it. So even a real looking website could be faked. And in this case, it was just made up by the bad actor. Now, there is a real attorney that actually has this particular name, but she doesn't practice in trademark law. And her bar information on the bar website shows a different email address and a different phone number. So that's going to be one of our tips here of ways to potentially spot something like this. Also, we want you to be aware of watching out for these text-only or email-only instructions, because that's a sign that the person who's operating a scam doesn't want you to hear their voice. Now, in this case, the victim caught on and accused the bad actor of running a scam. And in response, the bad actor tried to prove that they were offering some sort of good service by pointing to a review website. Well, that's not ordinary attorney behavior. If an attorney is being accused of a scam, they're not going to usually turn around and say, oh, I'm not a scammer, see my Yelp review or something like that. In this case, the attorney was the only person who was reviewed on this particular website. So we're pretty sure that the bad actor, just same as setting up a website, set up a review website. So what can you do to be sure you're working with a real attorney? If you have concerns, look up the attorney on the State Bar website. And if the contact information is available for the attorney there, make sure it matches the contact information you're using to communicate. If it doesn't, you could try emailing or calling the number that the bar has to confirm that it's just alternative information for the same attorney. It's not uncommon for an attorney to potentially multiple email addresses or work at a couple different offices, but you should be able to correspond and just confirm that information. Now, victims of scams are not just individual applicants. Attorneys can be victims too. It's common for one attorney in a jurisdiction to work as local counsel for attorneys or other similar legal agents from a different jurisdiction. It happens all the time. However, a U.S. attorney who decides to act as local counsel for a foreign trademark owner filing in the U.S. becomes the attorney for that owner and is ultimately responsible for counseling that owner. So this local counsel situation can be problematic if a client has no means by which to contact the U.S. counsel, or where the client is unable to communicate with counsel at all. So U.S. attorneys are subject to the ethical and professional rules, not only of their own states, but the USPTO's rules of professional conduct too. So this is an example of a real solicitation sent from a foreign agency to many US attorneys. First, I want you to notice how the foreign agent is looking for a partner and not just local counsel. That's a huge red flag. A partnership arrangement suggests a lot more than acting as a local attorney for some of the foreign firm's clients. This immediately raises concerns about rules against fee splitting, independent professional judgment, sponsoring unauthorized practice of law, among several other rules. But this example only gets worse because it indicates that we are now looking for a partner to use their federal attorney license and mailing address. And I shouldn't have to say it, but it's plainly unethical to rent or borrow a law license or for an attorney to allow that to happen. Now, attorneys are allowed to directly supervise support staff, who in turn may help the attorney with trademark-related work. However, a foreign agent or attorney who directs the work of the U.S. attorney is not support staff. This arrangement raises immediate ethics concerns. The USPTO.gov account agreements explicitly prohibit an attorney from sponsoring an account for foreign counsel. The attorney is also ultimately responsible for anything done with those sponsored accounts. Now, why do we raise this? Well, attorneys who have decided to work with high volume filing mills in the past have been burned. We are aware of several attorneys who may have started with good intentions, expecting to review every submission and work to advise the client, but quickly found that by sharing login credentials or sponsoring the foreign attorneys or agents as if they were support staff, the foreign mill began using the attorney's signature on correspondence and submitting documents without the attorney reviewing them. Under USPTO account sponsorship agreements, that attorney remained responsible for the misconduct and the potential ethical and professionalism ramifications that came with supporting UPL. I want to point out a new type of scam here. This is a misleading text. Now, I want to first note that the USPTO doesn't actually currently send text messages for filing reminders. We do use texts for account verification purposes, as Sarah's going to talk about in a moment. But we don't actually do this for renewals and things like that. It might be a good idea. We might look at it in the future, but not something we're currently doing. So if you receive a text right now, that's probably not correct. But another thing to spot here is how the bad actor is directing the user to file an affidavit of use at a particular website. And again, that website, I blurred it out here, but it does say .com. It's not .gov. A little more nuanced here is that the message tells the registrant that it's time for you to properly file something. The USPTO may direct you to use specific forms if you wish to file something, but we're not going to tell you that you must file it. We'll only tell you about deadlines to file or what will happen if you don't file something. But directing you to file something like a renewal application suggests that we know that you are still using your trademark, and we do not know that. So the other thing is the victim here thought that he was texting with the USPTO. He indicates that he called the office to confirm that somebody was confirmed that something was filed. While he was confused about this text message, we're actually glad he reached out to the office directly. And that's actually a really great segue to our next topic, because we want you to be aware of who you're talking to on the phone and make sure that you're always calling phone numbers that are actually associated with the USPTO. With that, I'm going to go ahead and pass the presentation over to Dustin to discuss phone spoofing and how people can sometimes appear to be the USPTO.
Thank you, David. Now, caller ID spoofing, sometimes also referred to as phone spoofing, is a problem that is not just being faced by USPTO, but is also being faced by many businesses and even other government agencies. First, I'd like to define what is spoofing. Spoofing is when a caller deliberately falsifies the information transmitted to your caller ID display to disguise their identity. For example, your caller ID on your telephone might say that a call is coming from USPTO and the phone number 571-272-1000. But scammers have the technology to make this information appear on your phone, even if the call is not coming from the USPTO. Now, why do scammers do this? Do you answer unexpected calls from numbers you don't know? Maybe sometimes you do and sometimes you don't. But many people are not even aware that it's possible to spoof a phone number. So they're more likely to answer if they recognize the name and number. When a call comes from an entity that you already trust, it makes the scammer's initial goal of getting you to answer the phone that much easier. So who's being called? Most frequently, we're hearing from current trademark applicants who have just filed an application. If you have filed recently, please use caution when receiving a phone call regarding your trademark application. We believe that scammers are taking data from our public records and calling recent applicants to solicit services, and sometimes even impersonating USPTO employees when doing so. Now, I'd like to remind you, as David mentioned before, that our current timelines for reviewing applications are at about 8 months after filing. So if you're receiving a call within a couple of days or even a month after you've just filed, unless you've filed a petition to make special, this is highly unlikely to be an authentic USPTO employee. I'd also like to remind you, though, that USPTO's examining attorneys do routinely call our applicants to address outstanding requirements that can be addressed via examiner's amendment. But again, USPTO employees, including examining attorneys, do not request credit card information. They don't do it over the phone, they don't do it over the email, and they don't do it via text. All USPTO payments are processed via pay.gov through the uspto.gov website. A request for payment to USPTO by any other means is a red flag. And if you receive this request, please end this communication immediately. Also, while less common, please be aware that even individuals and businesses who have never even filed with USPTO have been targeted for trademark-related scams, including caller ID spoofing-related scams. Now, we believe that scammers may be looking at recent state filings related to business incorporation, business formation, or even requests to change an entity's business name. So please be aware that even if you don't have any prior history of filing with USPTO, individuals and businesses have been targeted for this type of scam, even without that relationship. And again, scammers try to create a false urgency. Most of our reports of this type of scam have included a request for prompt payment, sometimes immediately or sometimes within a short time frame, such as 24 to 48 hours. And as I mentioned, scammers often do so while impersonating real USPTO employees. We've had reports that these scam callers have included threats to further delay the processing of a trademark application, or sometimes a report that a third party is filing for the exact same trademark, and that quick action on behalf of the applicant is required to prevent the other party from filing first or having priority. Now, USPTO employees cannot arbitrarily delay your application, and they will never prompt you to file quickly to gain superior rights over a third party. And most importantly, USPTO employees do not request payment over the phone, text, or via email. Now, what does a spoof phone call look like? Our investigations have shown that scam callers try hard to appear authentic. They're spoofing real USPTO phone numbers like 571-272-1000 or 800-786-9199. And they often appear as if the call is coming from Alexandria, Virginia, the location of USPTO's headquarters. Sometimes these scam callers even use the name of real USPTO examining attorneys when making these calls and impersonate them. And the scam calls can even be accompanied by forged office actions or fake emails. We often hear reports that these types of documents may be sent to the person receiving the call after they've received the call. Unfortunately, using current technology, it's very difficult to distinguish a spoofed phone call from an authentic phone call using the caller ID alone. This is why it's important to pay close attention to any calls, any unsolicited calls related to your trademarks. And also a reminder, as David had mentioned before, be on the lookout for demands for unnecessary or nonsensical fees. If you're not already familiar with them, please become familiar with USPTO's fees. And you can review the USPTO's trademark information, and there's a link to our trademark fee information on the flyer that accompanies this presentation. And as David mentioned, if the particular fees aren't listed there, you can always refer to the fee schedule, USPTO's fee schedule, which has a comprehensive list of all of USPTO's fees. Now, sometimes the amount of fees requested can raise suspicions by themselves. We've seen requests for thousands of dollars of fees for procedures that don't even exist. Like David mentioned before, fees for federal taxes, or sometimes for a fee for attestation from the 50 states. Fees like this aren't even part of the trademark process. So now, what can you do? In addition to the other steps we routinely recommend for any suspected fraud, if you receive one of these phone calls, we recommend reporting any spoofed phone calls to the Federal Communications Commission. And there's a link to this reporting form on the flyer that accompanies this presentation. And we'd also like to make you aware that the FCC is working on solutions that may make it more difficult to successfully spoof phone calls in the future. But we want to make you aware of this now, as this is an ongoing issue that we're seeing. So as a reminder, USPTO employees do not request payment over the phone, via email, or via text. And if you suspect that you are being targeted for a scam, you may always verify a USPTO employee's identity. You can ask to call them back. And even though USPTO employee phone numbers are often listed at the bottom of official USPTO office actions, we note that we are seeing instances of forged office actions. So our recommendation would be to use the USPTO employee locator, and there's a link to the employee locator that can be found on the scam resources flyer that accompanies this presentation. In addition to double checking the contact information for the contact that may have contacted you via phone and calling them back, we also recommend, if you confirm that that you are the recipient of a spoofed phone call, if you could please also contact the Trademark Assistance Center. We are using this information and tracking it, and we're using the Trademark Assistance Center to help track this information. So far, the scams you've heard about have historically targeted trademark applicants or potential USPTO trademark applicants. But we're also seeing scams directed at registration owners. So with that said, we'd like to tell you some more about the most common scams that we see post-registration, which often target trademark registrants around the time that maintenance filings are due. This is also a good time to remind you that the scams we've talked about so far have historically targeted applicants, and the ones I'm about to tell you about now have historically targeted registrants. But scammers are good at adapting their schemes. So this is a reminder that just because historically certain schemes have targeted applicants or registrants, that may not be the case going forward. So for any attorneys attending who've practiced trademark law for a while, or even trademark owners who've held registrations for several years, you may have seen solicitations targeting registrants as you approach key dates to maintain your registrations. Prior to joining USPTO, I know I had seen quite a few of these. But we'd also like to point out that some of these post-registration solicitations have even changed over the years. And similar to the scams that target trademark applicants, most of these solicitations aim to create a false urgency at some point and request prompt action or payment. And as a reminder, the post-registration maintenance filings are typically due, they're due between the 5th and the 6th year after registration, and then again between the 9th and 10th year following registration, and then again every 10 years thereafter. So we've seen solicitations from third parties often a year before a registration owner is even permitted to submit maintenance filings to USPTO. And this is something that we've seen change over time. The solicitations that are usually delivered via US mail have historically been sent out around the same time that you would be expected to file your maintenance documents. But now we're starting to see them be sent out a full year and also include unauthentic dates on the mailers. So often they list the date to be a full year before your maintenance filings are even due. And many post-registration solicitations are often disguised to appear like they're coming from USPTO. Companies sending these solicitations often use names similar to USPTO or the United States Patent and Trademark Office in an attempt to confuse you. The requested fees are often much higher than USPTO's actual fees, and sometimes it's unclear if US licensed counsel is even involved in their services. And as we've mentioned earlier in this presentation, depending on the circumstances, this could put your maintenance filings and even your registration at risk. Please be aware that USPTO is not affiliated with any parties sending solicitations to you and offering to help maintain your registration, despite any claims to that effect. So next, I'd like to walk you through an example of a post-registration solicitation. As I mentioned, many of these are delivered via US mail to the mailing address of record for a USPTO registration. Now on the top, you'll see an egregious example of an entity that's unaffiliated with USPTO that uses a confusingly similar name. Here, the name is listed as the Patent and Trademark Office with an address in Washington, D.C. This is also a good time to remind you that USPTO's headquarters are in Alexandria, Virginia, and not Washington, D.C. And also on the top right, you'll see that the web page that is listed on this particular solicitation ends in .us. So we'd also like to remind you that websites for US government agencies always end in .gov. Another point we'd like to point out is that this is just a general tip related to these solicitations. They often include a QR code. And just a reminder that the QR codes point to a particular website, and sometimes the websites can be malicious. So just a reminder that if you receive a solicitation like this, it's probably not a good idea to use that QR code. And next, as I mentioned before, the particular dates listed on these solicitations are not always authentic. So this is a reminder to double check the dates required for maintenance on TSDR. And you can, if you've received a reminder from USPTO, there will even be a new tab, a maintenance tab, when you enter your serial registration number with those particular dates when you're required to make your filings by. And lastly, we'd like to point out that these solicitations often include a disclaimer. The disclaimers, however, often include language that make clear that this is a private solicitation from a private business and is not endorsed by the US government. Sometimes they may even indicate that they are offering a private registry that is not even associated with the trademark registration process at all. So now we'd like to end by reminding you, if you receive these types of post-registration solicitations, it's always a good idea to check the status of your registration and any due dates for your particular maintenance requirements and fees. And you can double check the trademarks status and document retrieval system to double check your dates. And you can always check the fees by double clicking that link on the flyer that accompanies this presentation. And also a reminder, if you have any questions and after you've received one of these solicitations, you can contact your private attorney if you have one, or if you don't, or even if your attorney has questions about it, either of you can contact the Trademark Assistance Center with questions about post-registration maintenance requirements and fees. And with that, I'd like to turn the presentation over to Sarah.
Okay, so now we'll discuss a few ID verification related scams. So first, what is ID verification? As you know, if you have filed a trademark application or any other documents via TEAS, which is our electronic filing system, since August of 2022, you must use an ID verified USPTO.gov account. Now this can be achieved a couple of different ways, namely electronically using ID.me, or on paper by submitting a notarized form to the USPTO. Most customers use the electronic process. Here is a screenshot of our ID verification page. If you would like further information on the process, there is additional information available on the USPTO website in the trademark section, including a video explaining the entire process. So, what scams are we seeing related to ID verified accounts? The first is a scam in which the USPTO.gov account is created using an applicant, registrant, or prospective applicant's name, but the scammer retains control of the account. This is done by using an email address under the scammer's control in creating the account. The applicant, registrant, or prospective applicant is then instructed by the scammer to log in using a password usually provided by the scammer to complete the ID verification process. And because the scammer also controls the email address associated with the account, the person who has been scammed does not see the emails about ID verification or any other communication from the USPTO. The result is that the scammer has control of a verified USPTO.gov account in another person's name that can be used by the scammer to conduct business with the USPTO, such as filing trademark applications. The second scam is where an applicant, registrant, or prospective applicant is contacted, usually via unsolicited text or email, and told to provide copies of identifying documents, such as your passport or your driver's license, or other personal information to a scammer. The scammer will often pretend to be a USPTO employee, such as a USPTO ID verification representative, who will assist the applicant in the ID verification process. The result? The scammer has access to your personal documents, which they can use for all kinds of purposes, not limited to attempting to obtain a USPTO.gov account or file a trademark filing. Please note that the USPTO does not employ USPTO verification representatives, as ID verification is completed using ID.me. Although our TAC and TEAS employees, staff may help you navigate the process if you reach out to them, they will not reach out to you unsolicited, and they will not create an account for you or ask you for copies of your personal documents as part of the ID verification process. So just to recap, how can you prevent these scams? First, make sure the email address you use to establish your USPTO.gov account and to complete ID verification belongs to you and is under your control, as in you have the password. If you have already established a USPTO.gov account and completed ID verification using an email not under your control or an account not under your control, or that was provided to you by an outside party, please contact the USPTO and ID.me as soon as possible. Second, USPTO employees will not ask for copies of your identifying documents as part of the ID verification process. If a person states they are a USPTO employee and asks for a copy of your passport or your driver's license as part of ID verification, you may be the target of a scam. Third, remember, USPTO employees will not set up a USPTO.gov account on your behalf. While the TAC and TEAS staff may provide support, they will not contact you unless you first reached out to the USPTO or ID.me to ask for help. So be wary of unsolicited communications. I know you've heard that a few times in this webinar, offering to help you with ID verification. The USPTO will not send you an unsolicited text offering to help you with ID verification. Now, there are 2 points in the USPTO.gov account and ID verification process where you may legitimately receive a text from either ID.me or the USPTO. First, during the ID verification process, you will receive a text from ID.me confirming that you intend to register with the USPTO. And second, like many websites, the USPTO does use two-factor authentication to log into your account. So you may receive a text as part of the login process. But if you receive an unsolicited or out-of-the-blue text or phone call asking you to speak with a USPTO ID verification representative or something similar as part of the ID verification process, this may be fraudulent. The USPTO will also not reach out to you unsolicited by phone and offer to help with ID verification. In fact, the USPTO will not call you about ID verification unless you have requested a phone call. And finally, a good general tip, do not share your USPTO.gov username and password with anyone. All right, now we've gone through several different scams. I hope that information was helpful. Now we're going to share some general tips for attorneys and then for applicants, registrants, and prospective applicants. So I'll start with the tips for attorneys. Okay, first, we have a couple of tips for attorneys in protecting yourself and your clients. The first is to be careful with cooperation solicitations, as we discussed earlier in the webinar. Some of the solicitations out there are designed not to actually retain your services in representing clients, but rather to obtain the use of your name and BAR number, so be careful. Secondly, even if you have not responded to a cooperation solicitation and you believe your name, BAR number, or other identifying information has been used without your consent in any USPTO filing or correspondence, please contact the USPTO as soon as possible. And if you have questions about your ethical obligations, please contact the Office of Enrollment and Discipline. For your clients, please educate them about the possibility of being contacted by scammers. Let them know that correspondence about their application or registration should be sent to you. And if they receive correspondence about their trademark application or registration, let them know that they should send it to you before replying. Finally, let your clients know that once their mark is registered, they may receive courtesy email reminders from the USPTO about registration maintenance filing deadlines on the first day when those can be submitted to the USPTO. But they may also receive emails from scammers. Scammers may contact them, sometimes using names similar to the USPTO's in order to fool them, and will often ask for payment. They can avoid being scammed by checking the actual filing deadline using TSDR and the amount of the USPTO filing fees by reviewing the trademark fees page on the USPTO website or by contacting you. All right, now I'll turn it over to David, who will share some pointers for trademark applicants and registrants.
Okay. Thank you again, Sarah. So, of course, as we've said several times now, we want you to be skeptical of all unsolicited communications. Do not give out your credit card information. The USPTO doesn't take credit card payment information or debit card information via text, phone, or email. And all trademark fees are paid when you are submitting a document via the Trademark Electronic Application System, or TEAS. Be mindful of what fees you are paying and question deadlines. Again, deadlines that look like they are a day, 24 hours, 48 hours, 72 hours are a red flag. Fees are listed on our website and at the link provided in the handout, but make sure that you understand what that fee is for. Bad actors like to try to make it seem like all the fees on our website are due at once, when that is almost certainly not the case. False urgency is a big sign of a scam. There are real deadlines, but the USPTO doesn't send out surprise office actions where immediate action is required. Most office actions for most issues are give a party 3 months to respond. An assigned examining attorney may call or email you to seek minor amendments to an application before it publishes, but you can check the status of your application at tsdr.uspto.gov to check if somebody contacting you is the actual employee assigned to your application. Remember, it could be upwards of 8 months before an examining attorney is even assigned. So if you receive some sort of correspondence days after you filed, be skeptical. If you have questions about a communication, feel free to check with us. You, or if you're represented by an attorney, the attorney can always contact the Trademark Assistance Center to ask about any particular document, phone call, or email that was received to verify that it was legitimate. Okay, so what happens if it's too late? If you've already been scammed? Well, we have the big 5 listed here. You should always report financial scams to your bank or credit card company. Banks are often required to provide some measure of fraud protection. We would like you to submit a fraud complaint to the Federal Trade Commission. That agency is tasked with investigating these types of fraud. You can also contact your local Federal Bureau of Investigation field office. The FBI will investigate certain types of computer and financial crimes. You can also contact your local attorney general. The attorneys general often have consumer fraud divisions. And as Dustin pointed out, you can report phone scams to the Federal Communications Commission. Well, what about the USPTO, of course? What are we doing? Well, the USPTO is not a law enforcement agency, so we're not able to help provide restitution for money paid to a scammer or help directly have anybody investigated or arrested. But we are interested in information about current and developing scams because we can use that information to warn our stakeholders about them, like what we're doing here today. We can also use that information to issue sanctions to parties who violate our rules. And in some cases, we do share information with other agencies, including law enforcement. In other cases, we may even take action to protect the use of our USPTO name and logo, which is now actually a registered mark. We would like you to send us information about potential scams. If you have a particular email thread, for instance, that involves a scam, you can email that to tmscams@uspto.gov. We have attorneys, including several on the panel today, who help review that information to determine if we are able to take action. Now, we do try to respond to messages in that mailbox as quickly as possible, whenever possible, but if you have immediate concerns about a communication you received, particularly something that has that false urgency in it, contact the Trademark Assistance Center first. The Trademark Assistance Center should be your first point of contact for these things because somebody can actively, over the phone, help you through it and determine if that correspondence seems legitimate or not. So with that, we've reached the end of the presentation, and we want to thank you for attending, and we hope that we've provided some useful information here to help you avoid being scammed and provide suggestions for what to do if you've been fallen victim to a scam. And we do have time for questions, so if you're watching this presentation live, go ahead and ask the questions using the chat feature. If you're watching this presentation in a recording and you have follow-up questions, we first suggest contacting the Trademark Assistance Center using the contact information on the handout or our website. And if you have specific trademark scams that you want to share with us, you can email those to tmscams@uspto.gov. As always, if you have an overall trademark policy question, you can email that to tmpolicy@uspto.gov. So with that, Marisa, what's our first question?
Well, thank you so much for this wonderful presentation. We appreciate all of the information that was shared by all of the attorneys on our panel. Before I ask the first question, let me just briefly mention a couple of reminders. First of all, you're going to receive these slides. A link will be sent to you around 3:30 today, so don't worry, because we know that this was a lot of information. And one other ground rule before we start, unfortunately, we cannot provide legal advice. So here's our first question, and David, this one is for you. This is coming from Kevin. Kevin is seeking some clarification on one of the points that you raised earlier. He's asking, is it a problem if attorneys are reviewed on third-party websites? Is this in and of itself a sign of a scam?
Well, thank you for the question. Absolutely not. We don't mean to imply that attorneys can't be reviewed on third-party websites. But the example that we were referring to here is one where the scammer was the only attorney reviewed on that website, and where the scammer tried to convince the victim that he was working with a real attorney solely by pointing to a review. So that's what we were talking about there. It is absolutely normal to be reviewed on websites as somebody who provides any sort of service. Does that?
Yes,
Hopefully
that's very
answers
helpful.
that.
Yeah, I think so. I appreciate that clarification, and I'm glad we can answer that in real time. Sarah, here's a question for you. How do I know if I'm working with a real attorney? Where can I go to check to verify?
Well, that's a great question, Marisa. Thank you for asking. So you'll want to start by asking your attorney where they're licensed and for their bar number. Most attorneys won't have any problem giving you that information. And just keep in mind, it's possible that where your attorney is licensed may be a state other than where you live. And just a reminder, to represent you before the USPTO, the attorney has to be licensed in a US state or territory. Most state bar websites have attorney directories that show the attorney's name and contact information and their disciplinary history if there is any. That said, some do not. Some do not have an attorney directory, and some do allow attorneys to be unlisted. So if this is the case, give the state bar a call or send them an email. Most have contact information on their website and would be happy to verify that the attorney you're working with is actually an attorney in good standing. Now, as you'll remember, there are some scams that involve using an attorney's name without their consent, or their bar information without their consent or knowledge. So what you can do is compare the contact information that the state bar has on file with what you have. And if it doesn't seem to match, sometimes contact information can be out of date or whatnot, then feel free to contact the attorney using the contact information the state bar has provided. And make sure that that's actually the person that seems to be representing you. Again, and if you have questions, you can always reach out to the TAC, the USPTO, but your state bar is probably your first best stop. Thanks so much.
Thank you. That's actually really great information. Sometimes as clients, you forget that you do have some power to push back, even against folks who you think are attorneys. You certainly can ask for credentials. So thank you very much for that. Dustin, let's bring you into the conversation. Here's a question for you. The attendee is asking, can I request that I also be listed on the application to receive courtesy copies of correspondence, even if I already have an attorney?
Thanks, Marisa. That's a great question. And yes, your attorney is able to list up to 4 courtesy copy emails to receive copies of most USPTO correspondence. So even whether it's filed at the time of initial application or even added thereafter, your email address can be added to receive courtesy copies.
Okay, that's great, because that way, again, you'll be in the loop and you'll kind of see what information is coming directly from the U.S. Patent and Trademark Office. Okay, how about another question for you, David. Does the U.S. Patent and Trademark Office share registries or other information with third-party logo or web design companies? Because many times they always say, we got this information from the Trademark Office, the U.S. Patent and Trademark Office. What do you think?
Absolutely not. We do maintain a publicly searchable database, and that's the same database that bad actors could be using to search for applicants or registrants to become future victims. we do not work with any private entities on maintaining any other sort of separate registry. So with that said, logo design companies suggesting somehow that the USPTO is aware of some sort of new logo that they have prepared and saved on their own internal registry. We are not aware of that, and we do not share that sort of data back and forth.
Okay. All right. Thank you for that clarification. Sarah, back to you. A lot of folks are contacted by paralegals or non-attorneys that seem to have a lot of trademark experience. So this attendee wants to know, is that okay to have those folks help them with their trademark application?
Well, I'll go ahead and give the standard attorney answer here, which is it depends. It depends on whether that person is directly supervised by an attorney. A paralegal or non-attorney can only work on trademark matters under the direct supervision of a qualified attorney. If you are solicited by someone, they should have no problem providing you with the information the contact information for the attorney they work with. And if you have any questions, you can always reach out to that attorney to verify that they are in fact working with them.
Okay. Okay. Good. Let's see. Got some other really good questions. Dustin, this one is for you. This attendee is asking, what do I do if I notice that the email listed in our TSDR system for my trademark application is not actually my email address?
Thanks, Marisa. As David had started to touch on before, the first step for most things is to contact the Trademark Assistance Center. So first steps related to any sort of suspicious behavior or information that doesn't seem to add up. Your first step is to contact the Trademark Assistance Center, and you can ask them how to update your correspondence information to appear as you believe it should. And if you think that the incorrect information that's currently listed in your record is related to a scam, you can also report that information to our tmscams@uspto.gov email address. And if you believe that somebody made a mistake and filed something in the wrong application record, and there's information on the filing to indicate that it came from someone else and their contact information is there, we would recommend that you contact ts@uspto.gov to report that error and ask to withdraw that information.
Okay. Thank you for sharing that with us. Sarah, some of us, on the who are attending this webinar have experienced some of these same things that you guys have talked about today. And we want to know, what are the penalties for violating these USPTO rules of practice?
That's a great question. So it depends. I'm assuming this refers to the rules regarding who can represent you before the USPTO. And that depends a lot on whether or not the person is an attorney. Attorneys who violate the rules of professional conduct or who are believed to can be referred to the Office of Enrollment and Discipline or their state bar for investigation. This could result in an investigation, public discipline, suspension, or exclusion, which is USPTO speak for disbarment, or even a public or private reprimand or warning letter, or if the allegations are found to violate the rules of professional conduct. Non-attorneys who engage in unauthorized practice of law or represent another person before the USPTO in, for example, a trademark matter, may also be referred for investigation. So yeah. And then if documents are submitted for an improper purpose, it could, there's several sanctions that are listed in our rules. And as you'll recall, under certain circumstances, this could impact an application or call into question the validity of a registration.
Right. Okay. So there are some things, some steps, some penalties that the U.S. Patent and Trademark Office has in our arsenal to deal with this. But we think one of the most important things here, what we're talking about today, is how to be forewarned, forearmed, to sort of predict a bit of what is on the landscape and how we would address that. Okay, so thank you for that. Dustin, here's a question from Curtis. This goes back to the fees, and they really want to know, are all of our fees on our website? Are there any hidden fees that they should be concerned about?
No, I mentioned it briefly before. There is something called the USPTO fee schedule, and that lists the fees and even lists the part of the rules where you can find a reference to those particular fees. And the fee schedule listed on the website is updated periodically. Occasionally, USPTO's fees and the fee schedule may change, but those will be updated on our webpage as well.
Okay.
There is, for trademark specific fees, there is a list of very common fees, and that there's a link in the flyer that accompanies the presentation to the most common fees associated with both filing a trademark application, filing a statement of use, and also for the maintenance related fees.
Okay, terrific. And I think that Jay, who's our technical partner here on the line, he has put into the chat thread, or I think he put into our thread here some information, a link to our trademark fee schedule in case folks want to take a look at that and get some more information. Okay. David, I've got sort of a two-part question for you. I think it's a question that will lead right into the next. This is from another attendee. And they're wanting to know, where can they go to find out who their assigned examining attorney is? That's the first part.
Okay, so the first answer is, once the application is actually assigned for review, then this information will become available. So I want to just caution that if you go and look where I'm going to direct you and there's nothing there, it means that there is no assigned examining attorney yet. So you can visit TSDR, that's the Trademark Status and Document Retrieval System, tsdr.uspto.gov, and enter your serial number and then click on the word status. If you scroll down, there is a bar that says TM staff and location information. And in that field, it should have the identification of the assigned examining attorney and what law office that person actually works in. If it says new application processing, that's the signal that there is no assigned examining attorney yet. You can also look back at the prosecution history. There's a scroll down tab there for prosecution history to see what has happened in your file. You can see what the office has done with it. And when the application has been assigned to an examining attorney, there'll actually be an entry there that says that. So definitely you can check that.
Okay, and so the follow-up question is, then how soon can an attendee or just anyone, a trademark owner, contact this examining attorney? Do they have to wait until an office action has been issued, or wait until they receive some kind of suspicious correspondence to reach out to that examining attorney?
Well, generally we would suggest that you wait until an office action issues before contacting that examining attorney back. Or if the examining attorney were to contact you to seek an examiner's amendment, that would make sense to communicate with the examining attorney. In a lot of cases, an examining attorney will approve a mark for publication without needing to speak with you. So in many cases, there's no communication actually required. If you receive correspondence that you think is suspicious, though, you can contact the examining attorney using the contact information on our website. You can, again, go to that employee locator, which is the link is in the handout, to confirm that that communication is authentic. If you receive a communication from somebody who's an examining attorney and it turns out that they are not assigned to your file, it's probably not authentic. And again, I'll also note that if you're represented by an attorney, then only the attorney should be communicating with the office on your behalf. So if you receive a phone call from somebody claiming to be the examining attorney and you have an attorney, particularly one who has appeared in the record, that is a major red flag. You should be very cautious.
Very good point to raise. Thank you for that additional tip. And I see that Jay, I think, has also put in some information on how to access our trademark status and document retrieval system. I think that that's fair. Okay, Sarah, here's another question for you. The attendee is asking, what should I do if a document has been filed in my trademark application or registration that I did not authorize and my attorney did not authorize? What should I do in that instance?
Thanks, Marisa. Well, first you can alert the TAC about the issue, the Trademark Assistance Center. Their contact information is in the handout you received, and confirm that the documents have been filed without your authorization or the attorney authorized to represent you. TAC will then be able to instruct you on the next steps in the process.
Okay. All right. Another question, I think. Let's go to Dustin. Well, this is a question for you. The attendee is asking, what steps can I take to confirm whether a call or a voicemail has actually originated from the U.S. Patent and Trademark Office? I think we've kind of touched on this, but maybe you can reinforce this one.
Sure. And first I'd point out, if you do have a copy of the voicemail that you were able to forward, you can forward the voicemail to the Trademark Assistance Center. We do occasionally have voicemails that are forwarded to the Trademark Assistance Center, and if necessary, can also be forwarded to some of the attorneys focusing on these issues. And that's also helpful information to have for our investigations. But if you don't have that voicemail, as I mentioned before, current technology makes it difficult to confirm whether a call or a voicemail, for that matter, has originated from USPTO. So for now, the best practice would be to make an outgoing call back to the employee who's identified themselves to you to confirm the authenticity of the call. And we would recommend that you confirm the USPTO employee's phone, the staff member's phone number using the USPTO employee locator. And then we also encourage you to report any suspicious phone calls, whether you have a voicemail or not, to the Trademark Assistance Center to help us track these issues, and we can just help track the issues, and any information associated with that you may have would be helpful.
Okay, wow. Okay, so that's good to know. I didn't know that you could send that you appreciate having voicemails, but of course that makes sense. So thank you for that. All right, David, you ready for another question? This one is for you. All right. Does the U.S. Patent and Trademark Office get involved in issuing cease and desist letters on behalf of third parties, or act as a party in a trademark dispute in court, or provide clearance services for third parties? This is going to, like, exactly what do we do?
We register trademarks. That's
right.
what we do.
Right.
Yeah, no, we do not issue cease and desist letters. We don't handle enforcement of your trademark registration. So if you are a party who has received a trademark registration, and you want to stop somebody else from potentially infringing your mark, that is up to you. You would seek, you'd send your own cease and desist letter or hire an attorney to do that for you. You might seek the help of a court of competent jurisdiction. Sometimes these things are handled in state court. If it's a federal registration, you might be in federal court. But no, the USPTO does not do any sort of pre-clearance searching for parties. We don't issue cease and desist letters, and we don't get involved directly in the whole question of priority of marks. Now, the Trademark Trial and Appeal Board sometimes can be involved in helping determine priority disputes. But that would be during a cancellation proceeding, and it's or an opposition proceeding between two parties who are arguing, and the PTO itself is not a party to that type of proceeding.
Okay. Well, I'm enjoying speaking with you, David, so I'm going to give you another one.
Okay.
Okay. We've talked a bit about fees. Would you be kind enough to give us some more examples of bogus fees? Off the top, that if we ever saw a reference to these, we know that they are not coming from our office.
Well, again, those registration issuance fees or any mention of taxes should be an immediate red flag. But more often than not, what scammers are doing is charging multiple, either unnecessary fees that are based on real ones, or multiplying the fees many times what they ought to be paid, because many of our actual filing fees are based on international classes. And so a new application might cost $250 or $350 per class, depending on which filing option you choose. But that's a per class in international classes. And like goods and services almost always are in the same single class. We don't charge per good and service. So There are some other fees that could be due during the application process. If you filed an intent to use application, for instance, then there may be another fee due later if the application publishes and you receive a notice of allowance. When you file that statement of use, that fee would be it would be $100 per class. Maintenance fees are usually between like $225 and $525 per international class, depending on what the filing is. And again, that fee list, and I know it's in the chat now, that fee schedule lists all the current fees for all trademark filings. And if you retain an attorney to help you, the attorney's fees associated with those documents vary depending on the law firm. So we're not trying to imply that there's a particular set fee for attorney services. But the fees listed on our website should be accurate. And again, if you're being asked to pay for all of the fees at the same time or multiple fees at the same time, that's the red flag. I'm also going to want you to point you to the ID manual online. I mentioned it during the presentation just slightly. I don't know if it's in the handout. I think we might be able to share it in the chat. But that ID manual is easily searched for like goods and services, and you can see the international class assigned to those particular goods and services so that you can determine for yourself if it should be a single filing fee or multiple filing fees for your application. Finally, since we're on fees, sorry, I'm just a font of data on fees today. If you are an individual filer and you're worried about the cost of working with an attorney, first, I want to note that there are a lot of attorneys who charge very reasonable fees. So shop around. There are plenty of attorneys who do charge very reasonable flat fees for certain services. But one other less expensive option might be to work with a pro bono program through the USPTO's Law School Clinic program. I just want to hype that a little bit. Information about that program is on the USPTO website. Several of those programs only charge the government filing fee. They're pro bono otherwise. And there are programs all across the country that can work with small businesses or individuals on trademark matters.
Wonderful. Thank you for giving a plug to the clinics. I had a great time when I was a supervising attorney for one of those clinics at Howard Law School, and it's a terrific resource. So thanks for sharing that. Sarah, I'm going to let you close us out today with the last question going to you. This attendee is asking, how can I learn more about trademark scams as they continue to evolve? Because this seems to be an ongoing process.
So your best resource for trademark related scams would be the USPTO website. We have web pages on scams, the current scams we're seeing, and we're continuing to revamp those as we unfortunately see new ones. So that's probably your first and best resource. And of course, if you have a question related to a solicitation you've received or a phone call you've received, the TAC is your best resource for specific questions.
Right. Okay. And TAC is just a terrific place to go because guess what? You get to speak to a real live person in real time, which is just awesome. How often does that happen? Okay. So before we conclude today's presentation, let me just take a minute to thank our expert presenters today, Attorney Sarah France, Attorney David Mayer, and Attorney Dustin Bednarz. I also want to thank all of our attorneys that work behind the scenes to coordinate this event and to assist with the Q&A segment. Specifically, Director Mantia Givens-Pressey. Mantia is Director for the Trademark Register Protection Office. Attorney Bob Lavash, who's Senior Trademark Legal Policy Advisor in the Office of the Deputy Commissioner for Trademark Examination Policy. Attorney Jessica Ludeman, who's a Senior Attorney in the Trademark Legal Policy Office. And of course, my manager, Attorney Jason Lott, who's the Managing Attorney for Trademarks Customer Outreach. And just a few more reminders. Again, around 3:30 p.m. today, you will receive an email that contains the following: a link to a survey. We always want to hear your feedback on what's working and what's not. So please take a minute to respond. It should take you about 3 to 4 minutes. You'll receive a link to the presentation slides and a terrific handout that has other links to resources of where you can go for help. We'll be posting a recording of this webinar on our website, uspto.gov, and on YouTube in about 3 weeks. My name again is Marisa Terrell. Thank you so much for joining us today.